Namaste. Happy New Year to all our Sakshi TV viewers. Welcome to Sakshi TV special immigration show with attorney Prashanthi Reddy from Law Office of Prashanthi Reddy PLLC. And if you have any queries regarding immigration, feel free to call us. Our attorney will be glad to answer your questions. And so before we begin the show, please note that the information provided on this show is not a legal advice, just for information purpose only. So Sakshi TV or its agents will not be responsible for this. If you need any specific legal information, please contact the attorney directly. And today we are going to talk about I-485 immigrant petition for aligned workers. So we have our expert attorney Prashanthi Reddy garu, and without any further delay, let's begin the show. Hello Prashanthi garu. Good evening, Andy.
Hello, Andy. Prasanna garu, how are you?
Yes, yeah, I'm going to and wishing you a very happy New Year. And so we are so glad to have you here.
Happy New Year to you too, and all the Sakshi viewers as well.
Yes, thank you very much. And what is I-485 and what documents are needed and when should be filed? And can you tell us?
Yes, so this is our third video actually in our series of videos on educating our viewers on the green card process. So yes. The first video we had was the first show was on labor cert, which is the first step. The second show was on I-140, where we discussed how to file an I-140, what documents are needed, what problems can be encountered, and how to resolve them in filing of an I-140. Now, the third step, once the I-140 is approved, and more importantly, once the priority date is available, then you can file something called adjustment of status, which is if you're in the country, which is called a 485, which in the adjustment of status application, the form number is I-485. So that's what I-485 is. And if you're outside the country and your I-140 is approved and the priority date is available, then you file something called an immigrant petition, which is not the topic of our show today, but just to let the viewers know.
Yes, Prashanthi garu. Before we move on to further information, we have a caller, Andy. Gurucharan garu, please go on.
Yes, sure. Hi, Prashanthi garu, how are you?
Hello, good, thanks. How are you?
Happy New Year. I'm calling from Washington, D.C., and I got a question about the H1 extension. My H1 extension was filed last July, and it went to RFP with Speciality Occupation. This is my first ever RFP and Speciality Occupation RFP. So just to give you brief details about my H1, it's 15112, computer systems analyst with level 4 LCA. So my RFP is responded with different people got recruited in the company. All are having bachelor degree and got third opinion letter. I just sort of asking you, is it pretty common these days to get the RFP for Specialty Occupation?
So unfortunately, when you said you filed a systems analyst, that's why you must have seen me cringing. So because a systems analyst position is bound to get a Specialty Occupation RFP. So this is one of the positions that we have stopped using, and most attorneys, have stopped using the systems analyst position, because as soon as you use it, it's a trigger for an RFP for Specialty Occupation. But sometimes you can't avoid using it because I guess if the employer is not flexible with reference to the job title, what is important is the duties anyway, not the title. But we try to avoid that title if possible, and use that, and the use of that SOC code as well. So that we don't get an RFE, because then after getting an RFE, it's difficult to explain. Difficult to overcome that Specialty Occupation issue, because the main problem is for a systems analyst, what the USCIS says. I'm not saying this is correct or this is actually the law, but what USCIS is saying is they refer to something called the Occupational Outlook Handbook, which is a publication of the Department of Labor. And in that Occupational Outlook Handbook, which is OH for short, if you go online and check, systems analyst position, the educational requirement is bachelor's in computer science or engineering. So the fact that it is not specific, they're saying that engineering is too broad a field and it's not specific to one particular field, therefore it's not a specialty occupation. So they're saying it's not a specific specialty, and there's a whole law around this and arguments and counter arguments about what is specific specialty and what is not, and whether USCIS can use this to deny cases. But right now they are, and they've been doing it for a while. So in a systems analyst position especially, they can easily say that because the OH is clearly showing that it's, for example, if you use software engineer, it'll say bachelor's in computer science. It doesn't say anything else. It says bachelor's in computer science or related, but this says bachelor's in computer science or engineering, and then it lists several other fields. So unfortunately, the position used itself is problematic, but sometimes you can't help the position used. So right now, in order to respond to that RFE, you have to really explain now the duties in great detail and explain the complexity of duties and explain in a tabular form how those duties, why they require a bachelor's in computer science, provided you have a computer science degree. If you don't, that's another, a different issue again. Or at least the equivalent of a computer science degree is what you need to have. So there are ways of responding to the RFE, and we can talk offline because it's going to take the entire show just to talk about that. But yes, there are ways of still responding to it, but the job title is problematic.
Yes, Prashanthi garu, we have another caller, Shivakumar from Atlanta. Shivakumar, please go on.
Hello. Hi, Andy. Hi, Prashanthi garu. ఏం లేదండి, నాకు ఒక చిన్న క్వశ్చన్. యాజ్ ఎ స్టూడెంట్ నేను స్టూడెంట్ వీసా ఉండింది నాకు లాస్ట్ ఇయర్ వరకు. ప్రెసెంట్ మనకు ట్రావెల్ బ్యాన్ చేశారు. ప్రెసెంట్ ఇట్ ఈస్ ఎక్స్టెండెడ్ టు మార్చ్ 2021. నాకు అపాయింట్మెంట్ అయితే దొరికిందండి, వీసా అపాయింట్మెంట్ స్లాట్ అయితే దొరికింది. సో ఇప్పుడు నేను ఒకవేళ ఇండియాకి వచ్చినట్లయితే నాకు స్టాంప్ అప్రూవ్ అయితే కెన్ ఐ రిటర్న్ బ్యాక్ టు యుఎస్ ఆఫ్టర్ మై గెటింగ్ స్టాంప్ అండ్
Right. So the travel ban is not, it is for certain categories, and it's for H, L, J. So certain categories, the travel ban applies. It doesn't apply to all non-immigrants. So if you say you're on an F1 and you are going to apply for an F1 visa.
Actually, I am an F1, but I got my approval on H1
for
last
what?
year.
Approval for what? H1?
For H1.
Because you didn't tell us that
stamp,
part.
Yeah.
Okay, you forgot to tell us that part. So if you are on a H1, you got an approval, you need to go for a visa, you might be out of luck until, just wait and see, because Biden administration, by the way, to that Washington caller, you must know what is happening in Washington right now. Capitol Hill is being taken over by protesters, but they were supposed to certify the elections today, and it'll happen sooner or later. So once the Biden administration takes over, we have to wait and see what they do about these travel bans, and they might it's an executive order, so they can easily, revoke it. It's very easy to revoke it. It's not a regulation where it's going to, need a process to revoke. So wait and see for the new administration to come in and see if they remove it, and don't travel right now. But if you have to travel before we get any further clarity on whether the travel ban will be revoked by the new administration or not, then there are exceptions to that travel ban. You need to go through those exceptions and see if you fit into any of those, and then apply for a visa accordingly.
Right. Thanks for calling. And we have another caller, Prashanthi garu, Sanjay from Houston. Sanjay, please go on.
Hi, Prashanthi. How are you?
Hi.
Hi. So I have an approved I-140 from with a priority date of 2015. One of my attorneys told me that there is something like if the priority date becomes current, then the H-1B can only be extended for 1 year. So what is that rule exactly? Can you please explain?
So that's not, you're getting confused between 2 or 3 different laws, and 3 different laws are in place here. But with reference to the 1 year extension of H1, that is basically if your labor, if your I-140 is not yet approved, but your 6 years on H1 is expiring, then you can still apply for an additional 1 year on your H1 as an extension, provided your labor cert was filed at least more than 365 days ago. And presently, either your labor is pending, or you have not yet filed your I-140, or your I-140 is pending. Provided that you have not exhausted that period within which you have to file a I-140. You know that once the labor is approved, you have only 6 months to file the I-140. After that, the labor expires. So as long as you're within that 6 months, and it's been a year since the date that the labor has been filed, or if you have filed the I-140 and it's pending, then you can get an extension of 1 year. So that's the 1 year extension rule. It's nothing to do with priority date. I mean, the priority date is not available, obviously, otherwise you would file the I-140 and the 485. And then you presumably would not have to file, your H1.
Yes, thanks for calling. And we have another caller, Prashanthi Garu from New Jersey. Abhishek Verma, please go on.
Hi, so my question is, my wife already got her H4 last year. Her biometrics was all done. Now then, this year about in October, we filed for H4 EAD, just an H4 EAD application, not the whole extension thing. And her H4 EAD is expiring on April 6th. And we're just worried because it's taking a long time. We haven't received anything from the Vermont Center. So any idea on how much time it'll take, and what should we do in case it gets delayed because she just got a job?
Yeah, thousands of people literally are in the same dilemma that you're in with reference to the H4 EADs. And the processing time right now is horrendous. Earlier, if you filed the H1 and H4 and H4 EAD, everything would just get approved at the same time. Then they introduced a biometrics requirement, which already delayed the process. And now, in addition to that, because of COVID, and they're not able to recapture biometrics, and sometimes they're not reusing the biometrics like they should if there's already existing biometrics. This is further exacerbating the situation and causing delays and loss of job, etc., etc. So a lot of people are actually, where USCIS is concerned, there's not much you can do other than emailing and writing to them and informing them as to what is your, why you're requesting an expedite process, and what is the urgency. Now, everybody has the same urgency that you have with reference to job. One way is, of course, you can do that because there's no harm in doing it. You can approach your local congressman, again, because there's no harm in doing it. But what success you will have is to be seen. But the best way to ensure that they look at your H4 EAD or your spouse's H4 EAD is pretty much, if it is beyond the processing time, then if it's like been 6 months or so since you filed and you still haven't received anything, then file a mandamus petition in district court, forcing them thereby to, look at your case. That's the only thing that can be done. The other thing you can do, which may have a limited success, is Ombudsman's office. You can contact them as well. But all these other agencies may or may not be able to help. The only way you can, for sure, at least get some response is through a mandamus claim.
Yes, thanks for calling. And Prashanthi Garu, moving on to our topic, I-485. As all we know that I-485 is the final stage of GC process. So exactly what documents are needed for this?
Right. So yes, as you said, 485 is the final stage for the GC process. And if you're outside the country, you file an immigrant petition. If you're in the country, you file what's called a 485. In order to file a 485, you would, of course, need an approved. The when you can file a 485, just to start with the when, is once the I-140 is approved and once your priority date is available. What is a priority date? Priority date is basically you have to go to travel.gov. In travel.gov website, you have to go to the visa bulletin. You have to check what is your category, which category you're in. We are today basically talking about employment-based green cards, so we're talking about employment categories. So there's several employment, EB1, EB2, EB3, employment-based categories. So you have to check which one you're in, and that will be given on your I-140 approval. And then you have to see what dates they're working on. If they're working on your priority date, then you can file the 485. In some instances, if the USCIS gives permission to do so, and it will be in the visa bulletin itself, they will allow you to use dates for filing, which is like a accelerated date. It's not an actual date which is available to you, but it's something that they're allowing you to do in advance in anticipation that the date might become current, moving forward. So they give you advance notice and allow you to file a 485 in advance. That happened as recently as October of last year, when thousands of people, Indian nationals especially, were able to file because there was not that much demand worldwide, because no one was coming into the country. There were no immigrant visas being petitioned. So that's when you can file. The priority date has to be available. Now, once you file, if the priority date is available, you have to file a 485 form. The 485 form is quite complex, and I would suggest not to do it on your own. There are many different aspects in the 485 form. One of it is, of course, just your just your information, basically your date of birth, name, address, last 5 years of where you resided, last 5 years of where you were employed. Now, this could be tricky if you're not trying to be accurate. Sometimes you just, guess, okay, maybe I started with this company in this month. Why do we have to be accurate about when I started? Yes, you have to be accurate, because when you're filing the I-140, if that also requires that you show experience letters. So if those experience letters and the dates there are not matching with their dates in the 485, there will be a problem.
Okay.
So you have to make sure that it matches, and there should be no discrepancy. The second thing I would say with reference to addresses, we might think that what difference does it make what address you write or what dates you put. If you're saying in your employment that you're working in Ohio, and you show an address of DC during that same period of time, then again, there'll be a question as to, why is this not matching? So the entire form, there shouldn't be any discrepancy. It should be like a story, a well-told story where, everything is matching. The other thing that is usually in a 485, the other crucial information that has to be filled out is the answers to the questions with reference to there's a bunch of questions asking if you did any bad things, if you were ever arrested, if you ever were out of status, if you ever stayed, if you ever worked illegally. So you have to read those questions really carefully, because if you answer wrong and then they find out something else, then they can really grill you at the interview. And if they think that you are trying to hide something from them or lie to them, then they can deny the entire green card petition. So you have to know what the question is. You have to understand the question and take legal help if you don't understand what the question means, and not just answer no or answer yes blindly. For example, one of the questions is, have you ever been arrested? Now, people don't understand what this means half the time, because sometimes even in a traffic violation, you can be taken to the police station, but maybe no charges are filed against you, but you can some tickets are written and then you're released. So half the time they don't even know that they've been arrested, but actually they have been arrested. And it'll come up in their record. So if they say, no, we've never been arrested, and at the interview, the officer will then pull up the record and print it out and give it to you and show it to you. Look, why did you say that you haven't been arrested? And they might think again that you answered fraudulently. You were trying to keep it from the USCIS, and just based on that, they could deny the case. So you have to be careful as to making sure that you answer every question accurately. Another example I can give you is, for example, if you have an EAD and it expires, and then you file for an extension of the EAD. Some people think that they can work on the EAD as long as the extension is filed, even though it's not approved. Okay. Because there's some previous law about it, so there's some confusion. So you might respond no, saying that you've never worked illegally. But then when you look at all the documents and you look at the dates of employment, it might show that you're actually working because everything is in the form.
Yes.
So it might show that you're working when you did not have any work authorization. And if you try to explain them that you didn't know what the law was, it's not going to work. So you need to find out what the law is. And if you found out that you ever violated the law, then you should put it out. Say, yes, I did work, but I fall under this exception. I work for less than 6 months without authority. So therefore, there is this section called 245K, which can help. And I'm using that 245K.
Okay,
So there are
Prashanthi.
many things. Yeah.
Yeah, we have a couple of callers. Let's talk to them.
Sure.
And from Atlanta, Samad Garu, please go on.
Yeah. So my question is the topic on which you are explaining. So I-485 dates came current for me in October, and then it has retrogressed at least 3 years back from my current date. So in the meantime, if I get another employment in a different category, can I just join it and do not file the 485 supplement J with them and continue to use the EAD which I received now, or should I start a new perm process with the new employer when the time comes?
So first thing is, I'm happy that you received your EAD and that you filed in October and you've already received EAD, because that's not many people have. People are still looking for their receipts. They haven't, received the receipts also as yet. But if you filed, then the one advantage of that they're giving you, allowing you to file early based on dates for filing, is that they're allowing you also to change jobs. So that's part of, the law, the AC-21, job portability. So if you file a 485 and if your I-140 is approved and 180 days has passed since the filing of the 485, then you're allowed to switch jobs, but you do need to notify USCIS by submitting a new 485J that the job has changed and this is the new job. And if they find that the job is similar to the previous job that you're working in, that the form has been filed, then you can seamlessly switch to the new employer. If they deny your 485J, then you'll have to refile the form. So that it depends on what your situation is. But no, you have to inform the new company, you have to inform USCIS about change in employment, because if you don't, and then they send an RFE and ask for a job offer letter, then at that point you will be asked as to why you didn't inform. So it's better, prudent for you to inform every time you change your job.
Right, we have another caller from Georgia. Shital, go on.
Yeah, my question is, my husband has filed I-485 with the downgrade of, this I-40, but it's like near about 90 days. Means he has applied in his date was 29th October, but till now we are just waiting for the receipt number, and we are not sure that means we are going to receive it or not, and USCIS has no answer for this. So in this case, what we can do?
Nothing you can do, just sit and wait, because as I told you that everybody is experiencing the same problem. The lockbox facility, the Texas lockbox facility is experiencing unusual delay because of the thousands of applications that were filed, and they are not able to process them as yet. They haven't even processed them. That's why they have not given receipts. We are only receiving receipts of cases that we filed on October 25th or 26th. So 29th cases, we have still not received any. So you're fine as of now. I know the anxiety because, until you get a receipt, you don't know whether the case has been accepted or not. Because cases can be sent back for the most frivolous of reasons. So I understand your anxiety, but there's nothing you can do other than wait for your receipt to come, and hopefully it should come in the next few weeks.
Yes, we have another caller, Mohammed from NC. Mohammed, please go on.
Hey, good evening, Ms. Prashanthi. Thanks for taking my call. I really appreciate it. I have a question regarding, it's a kind of a suggestion. My green card is in EB2 category, and I have a priority date of December 2011. So when all these dates moved, I was in dilemma whether to move forward with downgrading my EB2 application to EB3 or not. But, I was hoping for some movement in EB2 as well, but unfortunately there is no movement yet. So what do you suggest? Do you think I should wait some more time, or do you suggest to downgrade to EB3 and, file for 485 in this case, in this situation?
Haven't you? Right. So, but haven't you already missed the bus? Because you've been thinking and thinking, you just missed the bus, I think, because the January visa bulletin is already out. And is your date still current as per the January visa bulletin?
Not the final action date, but again, EB3 date, filing date is still current.
Dates for filing is not allowed in January, so you've missed the bus. Dates for filing is not allowed anymore in January. You thought too much, my friend. You should have stopped there thinking and taken action. Actually, a lot of clients did that, and when they came to me, I was like, what are you guys doing? I mean, because to expect EB2 to become current or to move that rapidly was just a false expectation, a false hope. So a lot of people who spoke to me did the downgrade and were safe. But unfortunately, I wish I had spoken to you a little earlier. But as of now, it's too late for you because they're no longer accepting dates for filing. It's only final action date, and most dates are not current because, that's 2009 for final action date. So you unfortunately will have to wait until something it happens again, and this time make sure you do it immediately.
Yes, if someone want to reach Attorney Prashanthi Reddy directly, you can call to 212-354-1010, and also you can reach her at prashanthi@reddyesq.com. Yes, Prashanthi, we have another caller. Yes, please go on.
Hi, Prashant. This is Santosh from Plano. I just have a quick question. So, I'm with the H1B and my wife is with the H4, and we have filed H4 EAD for my wife back in August 2021. And right now we have an emergency and we have to travel to India now. So we haven't got any update. I mean, the H4 EAD is still with USCIS in a pending status. So is it safe to travel now?
So your H4 EAD is not affected by your travel because you continue to be on H4 status. And if you have a visa and you're able to come back, then your H4 EAD is not affected by the fact that you traveled.
I already expired. We just have I-94 extension approved, but visa is not valid till our visa expired in May 2020. So
if you're able to come back, then as I said, your H4 EAD is not affected by your travel. Now your travel plans, obviously, once you leave, coming back is a different story. You have to get a visa, and if all goes well, and if you're able to get a visa and come back, your H4 EAD will not be affected by the fact that you traveled. It's not cancelled.
Yes, thanks for calling, Shanti. Recently, we discussed about criminal records. So what happens if someone have a criminal record and still they can adjust or not?
Right. So that was one of the questions. So again, continuing with what I was saying and bringing in what you were saying, you're asking me also. One of the questions in the 485 form, which we have to be very careful about, is have you ever been, as you said, we talked about have you ever been arrested. Now, let's presume it's not a traffic violation, but they were actually arrested and they were charged with some kind of a crime and they had to go to court and, So now the question becomes, what kind of crime was it? If there is an exception, not all, usually if you file anything, if you commit some kind of a crime, you don't get the green card. The 485 will get denied. But there is an exception to this. That's the petty offense exception, which basically means that if you've committed a petty offense, which means a small offense, or a misdemeanor in legal terminology. A misdemeanor is a crime that can be punished by a maximum of 6 months in jail or a fine. So if you've committed just a misdemeanor and it was not a felony or a serious offense, then we can, as long as we show them the court records and we show, now what is important is not what you were charged with, but what decision the judge finally made. So if the judge decided that, it's a misdemeanor, even though you were charged with a felony, then that's what's important. So you have to submit certified copies of the court records, and you have to give them the petty offense explanation. Your attorney has to write a brief about how you fall, whether you fall or not under the petty offense, and if you do, what are the facts of the situation. And then your case can still get approved in that situation, even though you have committed a crime.
Okay, right. We have another caller from Ohio. Vivek, please go on.
Yeah, hi. This is Vivek. I submitted all the documentation with the logbox in October, but still I'm waiting for the receipt. I didn't get any of the receipt. And then there is no update for the logbox support email as well. I'm just wondering, is there any clue that you can give what we can do, or is it good to wait, or we can go ahead and stop that check and reapply? That's my first question. My second question is, for reapplying, the dates went back. Now it is 1/1/2014. So the dates went back for me. So what we need to do? Do we need to wait, or is there any other chance? Thank you.
First thing is, the answer is very simple. You cannot do anything. If you want to withdraw your case, that would be extremely wrong of you to do that, because you are missing a golden opportunity. Why would you want to withdraw your case? And how can you refile it if the visa numbers are not available? So even the thought shouldn't occur, it shouldn't come to your mind about withdrawing the case. This is an opportunity that's given once in 10 years, once in 20 years. And if you say you filed it in a timely manner and now you want to withdraw it and refile it, when? When are you going to refile it? Again, 20 years later? What was the purpose in filing it to begin with if you wanted to withdraw? So no, that is not the solution. If you have not received a receipt, wait. You're not the only one who has not received a receipt. Thousands of applications have not come yet. We have not received receipts. In our office and in many other attorneys' offices, they have received only 50% of their receipts, maybe at the most. And I-140 receipts, if there are any downgrades, those are very few. So my advice to you is wait, because there's nothing much else that you can do. You can keep periodically checking your checks to see if they're cashed. If they're cashed, then you can expect a receipt within a week or 10 days.
Yes, thanks for calling. And Prashanthi, I have a question. What if child ages over 21 during the period of adjusting status? Is there an effect or not?
Right. So there is an effect if a person. So when you're filing the 485, you file obviously for yourself and you file for your dependents, your spouse and your children as well. At the time of filing the 485, if you're filing your case based on final action date, which is not what happened in October, they allowed us to file based on dates for filing, which is only a temporary date. It's not an actual date that's available to you. So if you're filing based on final action date, then the date that you file your 485, suppose your child is 14 and the dates go back after you file, you don't have a problem, because the age of your child automatically freezes along with the as soon as you file the application. But the problem is that if you file based on dates for filing, which is like this artificially available date, then the age of your child doesn't freeze. So you're out of luck if you don't get your green card, and if the dates retrogress and you don't get your green card, then your child is out of luck, because they will age out. They have to be under 21 as of the date that your 485 gets approved for them to get the green card. So there is something called CSPA, Child's Status Protection Act, based on which what they do is they deduct the time that it took for the immigrant petition to be filed. So, and the time that it took for the immigrant petition to be processed, not filed. So if your I-140 took 6 months because you didn't do it in premium processing, or it took a year, or it took longer than that because there were some issues with the I-140, then they will deduct that time from the present time of the child, and your child will artificially be that age. So based on that, you can actually file the 485, and you can continue processing the green card for your child, and they will get the green card. Otherwise, they're out of luck.
Prashanthi Garu, can you tell us, please, what is CSPA and how does it help?
Right. So sorry for the interruption, but we had some technical issues. But as I was explaining, I think I had completed explaining that aging, if people are aging out, then they can still artificially lock their age by reducing the amount of time that it took for the I-140 to be processed, and reducing that from their actual age. And then if they're under 21, then they can file the case. So that's the CSPA. And I had also mentioned that if they file the 485 based on final action dates, then they don't even have to worry about doing that, because if they were under the age of 21 when they filed, then automatically their age gets locked.
Yes, we have another caller from California. Jaya, please go on.
Hi, I have a question. Currently I'm in H4 EAD. I'm working with an employer. The same employer sponsored me for H1 and it got approved recently. And the start date is mentioned as last week. So I would like to know the current visa status, and is my H1 is active, and I'm by myself I have changed it to H1 or not? That's my question. And another question is, if I want to revert back to H4 EAD, if I want to continue my job instead of H1 to H4 EAD, what is the procedure? These are my two questions.
So just to get the facts straight, first you filed from a H4 EAD to a H1, and the H1 is now approved. Is that correct?
Yeah.
Okay, so then the date that the H1 gets correct, that gets approved, and of course the start date is also important. That's the date that you become, because you've asked for a change of status, and if the USCIS has granted a change of status, then your status if the status is approved, then you change to the status that you have requested, which is H1, as of the date of the approval. So you're on a H1 as of the date of the approval. Now, if you want to revert back to H4, then you will have to again file for a change of status from H1 to H4, and then again file for EAD and file a H4 EAD application, and then wait. I guess you can wait on you can continue to work on a H1 until the H4 EAD gets approved. And once your H4 EAD gets approved, then you can, change your employment also in your I-9 records to a H4 EAD.
Yes, we have another caller, Fayaz. Fayaz, please go on.
Hi, thanks for taking my call and question. So the question is, my friend also applied for the EB2 to EB3, and I also applied from downgrade EB2 to EB3. My friend got the EAD, and I got the biometric appointment for this January 20th. That is the one question. So why is there a difference? Because we work for the same employer, everything is same. So there is a difference in how they are handling the each application. And also one more is, if I go to India using the EAD, once I get it, I have my H1 until 2023, but it needs to be stamped. So in case if I want to come back, can I come back with EAD and still H1 will be active?
So the first question about why is each case being responded to differently, because they've received thousands of cases on the same day. So they cannot respond to each case in the same way because they don't have the ability to do that. And second thing is that USCIS is famous for not treating each case similarly. You'll have exactly the same facts, exactly the same. One case they will accept, the other case they will deny. So lack of consistency is the hallmark of USCIS. So you should be asking your congressmen and senators as to why why that is happening, and hold USCIS accountable for it. But I mean, on a practical note, I mean, if they have received 10,000 applications on one day, obviously they cannot process all of them on the same day. They're going to, process them throughout the week or throughout the month. So that is what most probably is happening. The second question with reference to can you travel on EAD? No, EAD you cannot travel. You have to travel on advance parole. EAD is an employment authorization document that allows you to work, doesn't allow you to travel. So if you have, presuming you meant advance parole, then yes, you can travel on an advance parole once it is approved. So you have to wait for it to get approved. Once you get the approval, if the validity date of the advance parole is still there, that means if it hasn't become invalid, then you can leave and come back during the validity date of the advance parole. And yes, you can continue to remain on H1 status even though you have re-entered on advance parole.
Yes, we have another caller. Sai, please go on.
Hi, Prashanthi. I'm Sai from New Jersey. I just want to know about the H-1B. So what happened is that recently I applied for H-1B visa in Chennai, and that is on January 20th. And I figured out that my passport is going to expire in less than 6 months. So do you suggest me to travel now, or do you want me to renew it here itself? Thank you.
I suggest you renew it and then go for a visa, because otherwise they might, when you're coming back into the US, they will give you an I-94 only until the date of your passport validity. That's what they do. And then you'll have to again file for an extension. So my suggestion to you is do an expedite passport renewal, and then leave the country and then do whatever, because coming back in is the problem. When you come back in, if you don't have validity, they will only give for the validity of the passport. So that's something you need to be careful about.
Yes, before we wind up, Prashanthi Garu, and if someone needs personal legal advice from you, so can you please provide your personal information?
Yes, which was done earlier in the show, but my phone number is 212-354-1010, extension 107, or you can dial extension 0. And my email is prashanthi@reddyesq.com.
Yes, thank you so much for spending valuable time here. Thank you so much, and a pleasure to have you on our show. Thank you.
Thank you.
Yes. చూసారు కదా, ఇది వాళ్ళ స్పెషల్ సాక్షి ఇమిగ్రేషన్ షో. చూస్తూనే ఉండండి సాక్షి, తెలుగు ప్రజల మనస్సాక్షి. నమస్తే.